Hello, I'm Dave Conroy, a security consultant with Bouncertraining.ie. Welcome to part 2 of our bouncer awareness workshop, where we're going to cover law regarding working as a bouncer. Good security is about hazard risk management. It's about assessing the risks and putting in place mitigating strategies to address them. Good security starts at home. Good security starts with covering your own ass first. If you can't cover your own ass, how can we expect you to do any good of a job covering anyone else's? Your own ass must come first, and you must learn how to cover that. Put value in yourself. So, for this reason, we're starting with law. We're going to start with employment law. Employment law is quite extensive. There's a lot to it, there's a lot of laws. I've taken the ones that I feel are most relevant to us, and I'm going to bring them up. And for any further questions on employment law, you can feel free to get in contact, get in touch. But for today, we'll just cover the ones I find most relevant. The Terms of Employment Information Acts 1994 to 2014 provide that an employer must provide with a written contract stating the particulars of the terms of employment within 2 months of commencing employment. Everybody's entitled to a contract, lads, saying what you get paid, how many hours you're getting, your holiday pay, the terms of your employment. It's a right. Employers are required by Section 14(1) of the Unfair Dismissals Act 1997 to 2007 to give notice in writing to each employee setting out the procedure with which the employer will observe before and for the purpose of dismissing the employee. This must be given within 21 days of receiving the contract. In other words, there's a procedure if he wants to get rid of you. There has to be a procedure. There has to be a dismissal procedure, and you have to be aware of that in writing within 28 days of getting your contract. Now, I wouldn't press any unfair dismissal case. I've seen, they usually say you have to be in the job a year before you claim unfair dismissal. But saying that, if you are dismissed under those same laws, you're entitled to a disciplinary hearing. You're also entitled to representation at that disciplinary hearing. Not by a solicitor, but by someone such as myself, a security consultant. And I think it would be a good idea, if you like your job, to get representation to keep it. The Payment of Wages Act 1991 gives every employee the right to a written statement every payday with every deduction itemised. You're entitled by law to a payslip, one with your own name on it. Under the Health, Welfare and Safety at Work Act, every employee is entitled to a safe working environment. In our next video induction, we will go more into this, and we'll go into exactly what constitutes a safe working environment and how to put in place a safe working environment. But you're entitled to, every employee, and in every industry has it. And security is no exception. And they might be flouting the law, but that's going to change. Everybody is entitled to a safe working environment. We're now going to look at some of the aspects of law that people seem to think that they think they know. But thinking you know and knowing is two very different things. As people often find out when the shit hits the fan, you know what I mean, and there's all sorts of trouble, then you find out what you know and what you don't know. So we'll just clear up a few things. Non-fatal offences against the Persons Act 1997. Section 2, assault. A person shall be guilty of an offence of an assault who, without lawful excuse, intentionally or recklessly, directly, indirectly, applies force to or causes impact on the body of another. or causes another to believe on reasonable grounds that he or she is likely to be immediately subjected to any such force or impact without the consent of another. I think that's self-explanatory. We can all understand what assault is from that. And this is where it gets tricky. Section 18, justifiable use of force. The use of force by a person for any of the following purposes, if only such as he or as is reasonable in the circumstances as he or she believes them to be, does not constitute an offence. That's not entirely accurate. Because no matter how reasonable you perceive them to be, it's the judge's perception that's all that's going to matter, not yours. So it doesn't matter how reasonable you perceive it to be. It's the judge's perception is going to matter whether you're in bother or not. Well, you're in bother either way if you're brought up on a charge, but he's the one going to decide when you get the conviction or not yours. In order to help with this, we have started using use of force continuum. We will be teaching this at a later stage in the programme where we can give you more guidelines on reasonable force and a better way of justifying your actions. Because if it is reasonable force, the main thing you have to be able to do is justify every action. So you need to be able to keep your head, remember what you're doing and why you did it, and have a reason for doing it. But as you will see in the use of force continuum, it's proportionate to what comes into you. No more. Absolutely no more. It can only be proportionate to what comes into you. Oh, we will go into that in more depth. Now, so we can use reasonable force for these purposes. To protect himself or herself or a member of this family, of that person or another from injury, assault or detention caused by a criminal act. So we can protect somebody else using reasonable force. Again, use the use of force continuum and be able to justify your actions. Don't ever let descent into revenge. That's an important one to remember. To protect himself or herself, and this is where your self-defense is coming in. To protect himself or herself, or with the authority of that another from trespass to the person. In other words, you're perfectly entitled to defend your reasonable space, your personal space. In our section where we actually go into working on the door and conflict management, we will teach you how to defend your personal space. That's very, very important. You don't allow anybody to trespass into your red zone. If you do, you could end up in big bother. You end up getting a headbutt and landing in the middle of the hall. To protect his or her property from appropriation, destruction or damage caused by a criminal act or from trespass or infringement. In other words, as we are a representative of the establishment, and if the establishment has a policy which would make somebody a trespasser. In other words, they have the right to refuse admission, they have the right to refuse the right to stay there and there should be a policy for, say, threatening behaviour, damage, abusive behaviour. You get the, spoiling anyone else's night, acting in an unsafe manner. These are all things, but there has to be a policy in place, and you should see this policy. So whoever you're working for, if it's in-house or if it's for a security company, but if you're working in-house in a nightclub, see what is the company policy on trespassing. What do they have to do? Because then you're not taking it upon yourself. You're not deciding, oh, you're trespassing. No, they trespass, they are in breach of the venue's policies and therefore are trespassing, and now they may be removed using reasonable force. Again, we will be back on the reasonable force, and we will actually show you there is a procedure in place. There should be a procedure for doing this. There's a procedure for everything, and you have to be. If there is also the health and safety aspects of it, you have to ask yourself: are you able to do this? How do you know you're able? Did anyone show you? Show you how? Are you able to show me how? This is a very, 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 very important part when it comes to self-defence, because from what I can see from posting videos in the past, there's a lot of people don't seem to have any out of Jesus clue what what self-defence is. This is very important. Subsection 4, section 20, subsection 4. The fact that someone had an opportunity to retreat before using force shall be taken into account in conjunction with other relevant evidence in determining whether the use of force was reasonable. Now, I could get very little out of the legal profession because nobody wanted to indemnify themselves when it came to actually asking and getting a definition exactly on what could be constituted as reasonable force, number one, and number two, self-defence. Because, as you can see, it's open to interpretation and the perspective of the judge. But I did establish one thing. If you lunge at someone with a punch, that's not self-defence. You have options. You can always go that way. You can walk away. You can talk your way out of it. But if you lunge at someone with a punch, whether you're in fear, it can only be proportionate to what's coming into you. So a block and strike is perfectly fine. Lunging at someone with a punch, that's not self-defence. Remember this. And if that's what's seen on the camera, you're going to have a hard time putting up an affirmative defence for that. Affirmative defence. If you're in trouble, this is what you're going to have to come up with. You're going to have to come up with, if someone's looking for money and they're in for compensation claim as a result of your actions or an incident may have happened in the establishment in which you work, you will have to put up an affirmative defence. And an affirmative defence to a civil lawsuit or a criminal charge is a set of facts other than those alleged by the plaintiff or prosecutor, which, if proven by the defendant, defeats or mitigates the legal consequences of the defendant's otherwise unlawful conduct. In other words, be able to justify your actions. Use the use of force continuum that we will teach you in a later stage of this course, and use this and use the terminology in this to write out your incident book. Be able to explain your actions. He did this and as a result I did this. Proportionate to what he did, I did. We'll go further into this. Another thing I would suggest, if you want to put together an affirmative defence, get yourself your own security consultant. Whatever about a solicitor, get your own security consultant. Tony O'Brien at Security.ie is one of the best security consultants in the country. I'd also like to say thanks for Tony for all the help he given me putting this course together. But get yourself a good security consultant, because let me tell you, the solicitors haven't got a fucking clue. Get a security consultant. They're in your industry, they know your industry, or myself. What we will put together, probably the best affirmative defence that you can come up with. That's really the most important aspects of law regarding working as a bouncer. At least now what we have established is what an assault is. We've established to a point what reasonable force is. We'll come back on that more. We have established that we can remove somebody from the premises for trespassing. We can defend somebody else. We have established what self-defence is, and we have also established, I hope, what is not self-defence. After that, then all I can say to you is, if there is an incident in your nightclub, I personally make a point of trying not to make any statement on the night. Because on the night, everything's up in the air, and do you ever find the next day, maybe 2 days later, you start to have flashbacks and you start to remember, oh yeah, that happened, or this happened. But it's too late going. Once your statement's made, your statement's made. Take a day or two, calm down, rethink the situation, know what you want to say, and go in and make your statement. Now, if the press sit on the night, and you're after being involved in an altercation, say you need to seek medical help, you need medical advice to make sure that you're in a fit state to give a statement. And as I say, if you're the head bouncer, make sure that you debrief your staff and make sure that they are in a fit state to give evidence for your incident book. Now, our next video will be on induction, where we'll go into what's involved in providing a safe working environment and talking about your safety, which will be also in the interest of your company to put in place a safe working environment. After all, it is the law. Thank you very much. I will see you for the next video.